Hello friends, I am Dr. Harsha Suryavanshi, Associate Professor from Sri Shivaji Law College, Parbhani, Maharashtra. In previous lecture regarding promoters, we had a reference of pre-incorporation contracts. In this lecture, we shall discuss what pre-incorporation contracts are and liabilities of such contracts. Pre-incorporation contracts are generally made by the promoters of a company which is yet to be formed or yet to be incorporated. These are the contracts expected to be made on behalf of the company before its incorporation. Generally, the promoters enter into the contracts maybe to acquire some property or some other things. For example, a contract with a solicitor to have legal advice or functions for formation of the company can be said to be a pre-incorporation contract. Similarly, contract with landholders to acquire some land or property for the company can also be considered as pre-incorporation contracts. Now, what is the effect of or consequences of pre-incorporation contracts? Since the contracts are formed before incorporation of the company, a company cannot be sued for pre-incorporation contracts. English and Colonial Produce Company Limited, very commonly known as Solicitor's Case, is a landmark judgment on this point. A solicitor in this case prepared the memorandum and articles of association of the company, and he paid the necessary registration fees as well as other incidental expenses. He did this on the instructions by some persons who subsequently became directors of the company. Later on, when the solicitor he asked for the expenses he incurred, the company refused to give any kind of costs. The solicitor sued the company for the cost, wherein the court held that it was not the company who is liable to pay the solicitor's cost, even if the company had taken benefit of his work. Here, the promoters shall be liable for pre-incorporation contracts. Similarly, the company cannot be made liable for the contracts even if the company has ratified pre-incorporation contracts. However, the liability on company can be imposed according to Section 15, Clause H of the Specific Relief Act 1963. Action may be taken against the company for specific performance of contract on satisfaction of certain conditions. These conditions include that the contract must be for the purpose of company, the contract or pre-incorporation contract must be warranted by terms of incorporation, the company must have accepted the contract, and the company had taken the benefits from the contract but it is refusing to perform its obligation. In such case, the company can be held liable even for pre-incorporation contracts. The next effect of pre-incorporation contract or consequence is, in case of pre-incorporation contracts, the liability is of the agents who are acting on behalf of the company. The pre-incorporated contracts can be ratified against the persons who acted on behalf of the company. Kellner versus Baxter case can throw light on this case. Kellner sold wine to a company which was to be formed by Baxter. Later on, company was formed by Baxter, but the company failed before it could make payment to Kellner. Kellner sued Baxter, who tried to shift the responsibility of payment on the company. However, it was held that promoters or any person who acts on behalf of a company which is yet to be formed shall be liable for pre-incorporation contracts. A company cannot sue on pre-incorporation contracts. In previous liabilities, we have discussed that the company shall not be liable, and in this consequence, we shall study that the company also cannot enforce pre-incorporation contracts. Natal Land and Colonization Company Limited versus Pauline Colliery and Development Syndicate Limited can explain the situation. The Natal Land and Colonial Company Limited agreed with the agent of the syndicate, that is Pauline Colliery, to grant a mining lease to the syndicate. Subsequently, the syndicate was registered. The syndicate discovered a seam of coal and it requested the Natal Land and Colonization Company to follow the contract. The Natal Land and Colonization Company refused to grant the lease, and the Pauline Colliery Syndicate sued the Natal Land and Colonization Company for specific performance of contract. It was held by the court that the company was not bound. That means the syndicate for which the contract was entered into cannot sue for specific performance of contract which was entered into by the syndicate before its incorporation. Thank you friends for watching the video. Thank you very much.